We are coming on the air right now because a shocking development just unfolded within the last hour. And what this reveals changes everything. According to official court paperwork obtained moments ago, a former president is facing an emergency judicial order that even senior attorneys did not expect. These are sealed records, portions redacted, statements made under oath, and taken together, they point to one thing: a legal system moving faster than anyone was prepared for. I want to be very clear. I'm not making accusations. I'm reading what's in the file, and what's in the file is explosive. Before we go any further, subscribe right now, because what you're about to hear is not being explained clearly anywhere else, and the details matter more than you've been told. Let me walk you through exactly what landed on my desk and why it triggered immediate alarms inside multiple legal offices. This follows a classic document dump scenario, but the timing is what makes it unprecedented. At 8:42 a.m. Eastern, a federal clerk logged an emergency motion into the system, not a routine filing, not a scheduling notice. An emergency motion marked expedited consideration. Attached to it were 19 exhibits. 19, that alone is unusual. But what raised eyebrows was Exhibit C, which is referenced repeatedly and then partially blacked out. Let me read this word for word from the motion itself. Given the credible risk of noncompliance, the court is asked to issue an immediate order to preserve jurisdiction. Read that again. Credible risk of noncompliance. Courts do not use that language lightly. That phrase usually appears when a judge believes someone might ignore, evade, or obstruct a lawful process. Now, here's where it gets worse. Attached to the motion is an internal memorandum from prosecutors dated 3 days earlier. It's stamped confidential and includes contemporaneous notes from a meeting held at a secure federal building. The location is listed, but the room number is redacted. The memo summarizes statements made by two senior officials, both unnamed, both identified only by title. And according to the memo, one of them said, under oath, that they believed time sensitivity had reached a critical threshold. Think about that. Time sensitivity, critical threshold. The next exhibit is a series of emails, 12 pages, internal correspondence. The subject line repeats over and over again with only one word changing: escalation, escalation revised, escalation urgent, escalation final. Not once, not twice, repeatedly. One email sent at 11:17 p.m. includes an attachment labeled contingency procedures. Large portions are redacted, but one sentence is fully visible. If the respondent fails to appear voluntarily, alternative enforcement mechanisms must be prepared. Alternative enforcement mechanisms. Courts don't write that casually. Now, let me slow this down, because this is the part no one expected. Exhibit H is a sworn declaration, 14 pages long, signed, dated, penalty of perjury. The declarant is described as a former insider with direct access to scheduling, travel, and communications. Their name is blacked out entirely, replaced with a code. But their testimony is detailed. Precise dates, exact times, specific locations. They describe a meeting that took place on a private aircraft hangar tarmac. The date is listed, the airport code is listed, and according to this witness, statements were made about leverage and delay windows. Let me read one line from that declaration. I was instructed to ensure that all outbound movements were flexible pending legal developments. Under oath. Read that again. The court didn't ignore this. In fact, during a closed hearing referenced later in the filing, a judge directly questioned government counsel about the credibility of this witness. The transcript excerpt is included. It's short, but it's chilling. The judge asks, "Do you believe this individual is telling the truth?" The response, recorded verbatim, is one word: yes. But it doesn't stop there. There are photographs, actual images entered as evidence, grainy, time-stamped, metadata preserved. One photo shows a stack of folders on a conference table. The labels are visible. Another shows a whiteboard with handwritten notes. Some words are blurred, others are not. One phrase stands out clearly: jurisdictional risk. Here's the part that raised alarms inside the courthouse. Alongside the photos is a log, a movement log, flight times, tail numbers partially redacted, locations matched against court calendars. And according to the analysis included in the filing, there are overlaps between scheduled appearances and recorded movements, gaps that cannot be explained by coincidence, but it gets worse. Exhibit L is a DOJ-style letter. Formal, measured, 3 pages long. It begins with a reference to ongoing compliance concerns. It ends with a sentence that should not be glossed over. Failure to adhere to the court's directive may necessitate immediate remedial action. Immediate, not future, not hypothetical. At this point in the timeline, something changes. The tone of the documents shifts. The language becomes sharper. Deadlines appear, exact hours. One order draft marked proposed includes a line authorizing action without further notice. That phrase appears twice. Read that again, without further notice. Inside sources later described a moment in chambers where even seasoned clerks stopped typing. According to contemporaneous notes included as Exhibit N, one clerk wrote, "This is moving faster than anticipated." Those are their words, not commentary, notes taken in real time. And then we get to the instant order itself, issued quietly, no press release, no public hearing, just a docket entry with a timestamp. The order compels appearance, specifies location, specifies date, and includes a sealed addendum that remains completely inaccessible. You have to ask why. Why now? Why this fast? Why this language? Because courts escalate only when they believe control is slipping. And every document in this file points in the same direction. A system bracing for resistance. We are only halfway through what's in these records. In a moment, I'm going to walk you through the testimony that triggered this escalation and the legal theory behind why an arrest was suddenly on the table at all. Stay with me. When we last left off, the instant order had been issued quietly but decisively, and the question hanging over everything was simple. What happened behind closed doors that made a court move this way? Now we get into the heart of it. Buried deeper in the file is the testimony that changed the temperature in that courtroom. This falls under the insider break silence framework, and it's not dramatic in tone. It's methodical, calm, almost clinical, which is exactly why it's so disturbing. Exhibit P contains excerpts from a sworn interview conducted less than 72 hours before the emergency motion was filed. The witness is questioned for over 6 hours. 6. The transcript runs more than 300 pages in total, but only selected portions were released as evidence. And the portions that were released are telling. At one point, the witness is asked directly whether the former president was informed of the court's expectations. The answer is not vague. It's not hedged. The witness says, under oath, yes, explicitly, more than once. Read that again, more than once. Then comes the follow-up. And what was the response? There's a pause noted in the transcript. Actual brackets, actual silence recorded. Then the answer, that it would be handled later. Later. That single word appears again and again in these records. Later became next week. Next week became after the event. After the event became conditional, and conditional became something else entirely. Here's the part no one expected. The witness goes on to describe a moment where legal counsel raised concerns internally. This isn't speculation, it's documented. According to contemporaneous notes, an attorney warned that continued delay could be interpreted as willful. That word matters. Willful changes everything. Let me read this word for word from the notes taken that day. Counsel advised that failure to comply could escalate exposure significantly. Escalate. There it is again. Now, flip forward a few pages and you'll see a series of text messages entered as evidence. Screenshots, time stamped, names redacted but roles identified. One message reads, "They won't actually do it." Another responds, "They might." And then a third message sent minutes later simply says, "Prepare anyway." Prepare for what? The court clearly had the same question. During the closed hearing referenced earlier, the judge zeroed in on this exchange. According to the partial transcript, the judge asked whether these messages reflected an expectation that enforcement action was possible. The government's response is clipped. Yes. This isn't about one document. It's about behavior. You see it in the pattern. Repeated delays, internal warnings, shifting timelines, and a growing concern inside the system that compliance was no longer guaranteed. If this were anyone else, the process might have unfolded quietly, incrementally. But this wasn't anyone else. This was a former president with resources, visibility, and leverage. And that changes how courts think about risk. Short sentences matter here. Risk of flight, risk of defiance, risk of precedent. You have to ask why the court felt compelled to act instantly rather than wait. The answer is hinted at in Exhibit R, a sealed risk assessment summary. Only 2 paragraphs are unredacted, but they're enough. One line reads, "The subject's public posture increases unpredictability." Public posture. That's not about guilt. That's about optics and momentum. Courts don't operate in a vacuum. They watch behavior. They assess signals. And according to these records, the signals were not reassuring. There's also a legal theory at play that deserves attention. The emergency motion cites a rarely used procedural mechanism allowing for immediate orders when the court believes its authority may be undermined. This isn't about punishment. It's about control, maintaining jurisdiction, ensuring the process itself isn't compromised. Think about that. This isn't a trial verdict. This isn't a conviction. It's the system saying, we need to lock this down now. And that brings us to the arrest question. Was an arrest imminent? The documents never use that word directly, but they circle it over and over again. Alternative enforcement, immediate remedial action without further notice. If this were anyone else, those phrases would be interpreted one way. But here, they carry weight, political weight, historical weight. The former president's legal team, according to a supplemental filing, argued that such measures were unnecessary and inflammatory. The court's response is brief, almost cold. The record does not support that characterization. Read that again. So where does this leave us? It leaves us with a former president facing a court that has lost patience, a judiciary signaling that status does not equal immunity, and a process that has crossed from negotiation into enforcement. This isn't about one moment. It's about a trajectory, a slow build that suddenly snaps into focus. And the implications go far beyond this case. If courts are willing to issue instant orders against someone this powerful, it reshapes expectations across the board for future defendants, for future officials, for the public's understanding of accountability. End this calmly, because calm is what seriousness demands. Here's what we know. Official records show escalating concern. Under oath testimony confirms repeated warnings. Internal correspondence documents preparation for enforcement. And a court acting deliberately decided it could not wait. This matters. Not because of who the individual is, but because of what the system is saying. No one is too large to compel. No timeline is infinite. And delay, when repeated enough times, becomes defiance. Thanks for watching. Subscribe, share this, and stay alert. Don't let anyone tell you this doesn't matter, because it does.